Hello, everyone. Welcome to the Gold Standard Consultation for our latest proposals to align Gold Standard certified projects with the Paris Agreement. Really delighted that we have so many of you with us today on the call and hope that we have a really productive discussion. I'll just quickly step through what we'll aim to accomplish today. I'm Sarah Lugers, the Director of Communications at Gold Standard, and I'll be moderating the discussion. But the really interesting content will come from Owen Hewlett, our Chief Technical Officer, who will go through the why we are doing this, why we're proposing these changes in the context of an evolving market landscape. And then the what, which will be led by Hugh Salway, who we're very happy to welcome to our team. It might be the first introduction many of you are getting to Hugh. He's heading up our environmental work, environmental markets work broadly. He'll talk about what we're actually offering for consultation and what we will plan to do in terms of next steps. And then we hope to spend a lot of our time answering your questions. So to submit your questions, please use the aptly named question function, and I will sort through those and assign an expert on our team to answer all your questions and hear your ideas as well. So with that, I will turn it over to someone who I hope has joined us, but I know was running a moment late, Owen Hewlett, who you all know very well, who will talk through the why. What's the context that we're facing that sets us up for where we are today? Owen?
Yeah, hi everyone. Thanks, Sarah. Can you hear me okay, Sarah, before I waffle on? Great.
Yep.
Okay. Yeah. Hi everyone. Well, what a brilliant number of you have come to join us today. We really appreciate that. We know this is a challenging time for the market, and the market indeed is going through various evolutions that we need to be across. So we don't take for granted your time, that's for sure. And as Sarah says, you'll be pleased to know that we have a new team member, Hugh, who will introduce himself shortly. So you don't have to listen to only my voice on this topic, which I'm sure will be a big relief to many people. And so that gives me the luxury of talking about the why in terms of the changes we're going to be implementing and that we want views on. And I appreciate that much of what people are concerned about is things like double claiming or market diversification. But there are a number of evolutions that are important, and we should make sure we see the wood and the trees in this one. In terms of the big picture why, I suppose we've kind of characterized this for nearly 3 years now of a watershed paradigm shifting moment for voluntary carbon markets across for a number of reasons, and sort of set out here. One is that the demand for voluntary markets of various applications, including offsetting, is inevitably going to grow. I'm part of the task force on scaling VCM. But even that notwithstanding, the market signal we're already seeing for supply and demand is expanding, and the diversification of that market is expanding, by which I mean, we should start looking at offsetting as one use, a very good use of the market, but not the only one. And with that comes scrutiny. Mark Carney's task force is not without criticism that it's received, and neither is the market. We know that there are articles coming through thick and fast. We ourselves have been interviewed for various topics in the media. With demand and opportunity comes critique and scrutiny, and we need to be able to bear that. We know as well that increasing voluntary action by corporates is a good thing. Science-based targets is 1,000+ companies. That has to be a good sign. But with that comes increased demand and sort of an increased squeeze, I suppose. I'm not saying that the voluntary market competes with science-based targets, but there are activities that could be either, and we need to make sure we don't undermine science-based targets while we rush to take up the opportunity that they are now starting to platform. And then lastly, pretty obviously, we have the Paris Agreement. So, we have increased demand, increased scrutiny, diversification of application, increased voluntary action in their own inventories by corporates, and just to top it all off, a totally new policy era. and it is a totally new policy era. The way of accounting for Paris, the mechanisms under Paris are not a carry-on of the Kyoto era. It is totally different, and we need to react to that to make sure that there is still space for voluntary carbon market action, and to make sure that things like baselines, additionality, double claiming actually make sense in that context. Because if they don't make sense, there will be no space for voluntary carbon markets. So it is a new paradigm, huge opportunity, hugely exciting, lots of change. Why for us do we want to align with Paris in that kind of morass of stuff? You know, Mark Carney's task force itself is proposing core carbon principles. Shouldn't that be the thing we align with? Well, we will do that, certainly, and we'll go beyond when it inevitably doesn't reach the standards we expect. But there's a really sort of important set of reasons to align with Paris. One is that we can't guarantee integrity unless baselines and additionality and double claiming and all of those fun things are aligned with Paris. We simply can't give the buyers of carbon credits a guarantee that they funded additional action without that alignment. And that will be increasingly important as Paris ambition hopefully ratchets and policies come into force. We also want to drive quality in the market. There's a very simple kind of philosophical reason, I suppose, to align with Paris. That is, why would we work on our own set of rules in the voluntary market and be separate from the biggest policy instrument of all time? It just doesn't make any sense. You know, it certainly brings complexity, but going it alone at this point when everybody is trying to go together would be a very strange move. And I think the one that's most relevant, I think, in terms of opportunity is applicability. I mentioned market diversification. You can expect to see voluntary markets used for a number of applications, whether it's a sectoral compliance scheme like CORSIA, a domestic carbon tax like South Africa, removals units being counted towards net zero by science-based targets, Article 6, all of these things, voluntary offsetting globally, all of these things are applications of markets, some of which are offsetting, some of them aren't. And if you want, as a project, to have the opportunity to leverage as many of those as possible, then aligning with the Paris Agreement is the best way to do that. And that's because all of those applications I mentioned will increasingly have to do that to make sense. CORSIA you could see as effectively an Article 6 instrument, even though it's not called itself that. It is entirely intentional that it aligns with much of the early text on Article 6, and I'm sure it'll continue to do that over time. So we see the same necessity in all markets. I guess the reverse engineer of that is we don't want to produce multiple sets of requirements that you'd have to meet to issue into those different markets. We want to create one set that is consistent and flexible, and that you have as many options, depending on what you're eligible for based on your project type and your vintage and your geography. So that's the other reason, consistency and applicability. It gives you the most opportunity as projects. We go on a slide there. We did, inevitably, when we come at a big change program like this, we start with a pretty blank canvas and we turn over all of the options that we have. And one of the steps we go through is to ask ourselves, what are our guiding principles for doing this? When we come across a difficult discussion and a difficult decision to be made, what is our reference point? And there's nothing new here. These go back as long as Gold Standard goes back in various written forms, and we shared them last year in a policy consultation and got great feedback. But I think all of these are important, but I think especially important right now are the third and fifth. I would like to think by now Gold Standard is a byword for quality, so I don't need to remind you what that means. But fairness is really important to us. Markets and Paris are technocratic instruments, and that kind of instrument means that some people have power and money and some people don't. And we want to make sure we continue to enable finance to flow to the ones that don't, because otherwise they could and will be excluded by our instrument, and that's not acceptable to us. We also want to try and give people as much time as possible to adapt. And then responsibility. So I hear a lot that Gold Standard shouldn't trouble itself with how its credits are being used, but I can't respond to that with anything stronger than my name being on the QA of that credit. So when we look back at our legacy as an organization, it will be remembered for how it served the different moving parts of Paris and voluntary action. And if we served those things wrong, if we knowingly did that and knew that the instrument could be misused, then that's a legacy we as individuals all have to live with. So while it might be really tempting to define what offsetting means based on what large, sometimes dubious corporates really want it to mean, we have to stand behind whether we back that instrument. And so we do take responsibility, not just as an organization, but as individual people, for what our name is put to. So I'm afraid you won't see us shy away from what are the correct uses of different attributes and credits, and be a big part of the conversation on what are the appropriate claims to be made. Because ultimately, when we look back on our careers, that will be what we're remembered for. So in terms of what we actually want to do, I'm going to pass that over to Hugh. As always, an awful lot of thought has gone into this already. These aren't things that have kind of come to us in a dream last night that we put down in a consultation paper the next day. But that's not to say that there isn't room for consultation. Like, we really do want to hear your views around those guiding principles, around the transition we've set. You know, I would say we're aligned with the civil society viewpoints on the key topics, but we also have a civil society voice ourselves, and can advocate for fairness and responsibility and all those other principles. So consultation feedback is meaningful and important, and we do encourage it. So with that, I'll keep quiet and pass to Hugh to take us through the facts.
Thank you very much, Owen, and hello to everyone. I've been introduced already, but my name is Hugh Salway. I am Gold Standard's newly appointed Head of Environmental Markets, and I'm going to probably take us up to around the half-hour mark, just giving an overview of what's in our consultation and providing more context on the different elements. And then that leaves then about half an hour after that to go through questions, and as Sarah said earlier as well, to hear kind of feedback and ideas, which follows on from what Owen just said about the fact that this is a kind of real, genuine consultation. So our consultation broadly covers 3 areas, all of which we see as necessary to align Gold Standard with the Paris Agreement. The first is requirements for projects wishing to transition to Gold Standard from other certification schemes, or existing projects wishing to renew their crediting periods post-2020. The second is requirements to ensure the avoidance of double claiming in the Paris context, which Owen's just talked a bit about. And the third part is several elements of project design that we see could require updates once Article 6 guidance has been adopted. And I'm going to go through these topics one by one before we move on to questions. So next slide, please. So first, the transition and renewal of existing projects. Our objective here is to ensure that Gold Standard projects still require carbon credit revenue in order to continue their operations, i.e., as we've said here, that they are vulnerable in the absence of carbon finance. And this is a basic principle of carbon markets and is necessary to ensure that carbon finance goes to projects that depend on it, rather than those that could continue in its absence. Gold Standard for our existing projects already requires information on a project's ongoing financial need when it renews its crediting period. But at present, this information is not used formally to determine whether it shall renew or not. And our proposal, which we put forward in the consultation, is that this will be a formal part of the renewal decision in order to meet that purpose. And the second proposal, which we have here, is actually already an existing rule, but we've included it here for completeness and in our consultation, so the full picture is there. And this rule is that projects from other certification schemes with a start date of first crediting period prior to 2016 must demonstrate risk of discontinuation at the time of transition. And we sought feedback in our consultation on 3 specific questions in particular on this area. So firstly, whether certain projects should be exempt from a vulnerability assessment. Secondly, the value for buyers of having a regular assessment of ongoing financial need, as we've proposed every 5 years. And thirdly, whether project developers consider this requirement to be reasonable, or if alternatives could be considered. And we are interested in feedback on those points. Next slide, please. So Owen mentioned this in his introduction, and it's one of the most prominent issues around the transition to the Paris Agreement context, and that's the avoidance of double claiming. And it's one that's had lots of discussion. And as Owen and Sarah said before, it's one that we've been publicly talking about for the past 3 years. And what's in our consultation is our proposals for how to implement this in practice. I just want to start, and what I've tried to do on this slide is show the transition here from the period in which we've just come from to the one in which we are going. So from at the international level, the Kyoto period to the Paris one. And to start by saying that Gold Standard already has existing rules in place to address double claiming risks. So at present, where a Gold Standard VER is issued in a country or region that operates within an international or a domestic greenhouse gas cap, emissions trading system, or carbon tax, we require the cancellation of an eligible unit before VERs can be issued. And this is our means at the moment of avoiding the double claiming risk. And this is relevant not in all places, but in some, so in Annex B countries that had compliance targets under Kyoto, for instance. And we put this in place to protect the integrity of the VER and of the claimant, so ensuring that buyers can have confidence in what they are buying and their claim to that. We're now entering a new policy context under the Paris Agreement. And as this slide tries to show, there are some kind of similarities there. And to me, to frame this, there's two things that remain the same and two things that are different. The first one, from our perspective, that remains the same is that there is a risk of double claiming, as there was before. And the second thing which remains the same is that in Gold Standard, we have an intention to address this risk to ensure that the integrity of credits is there and of the claims made when these credits are used. But what's different is that while at the moment this risk is relevant in some places, under the Paris Agreement, all countries have international targets in the form of NDCs, meaning that this risk is now much more universal. And the second thing that's different is that there is now a mechanism under the Paris Agreement to address the risk of double counting in the form of the corresponding adjustment. So whereas in the past we've relied on the cancellation of a unit, there is a mechanism there under Paris to address this type of risk. Next slide, please. So the purpose that is set out here that we have is to ensure that credits used towards offsetting claims fulfill the promise that the atmosphere is no worse off. So our intention here is really, as it has been in the past, to protect the integrity of our units, to protect the integrity of the claims made by buyers, and to make sure that where offsetting happens, as it says here, the atmosphere is no worse off. And this comes back to the point that Owen mentioned earlier about the fact that our name is on the certificate and we need to have confidence in the product which is there. So for us, when a buyer wishes to claim that their emissions have been offset by buying a Gold Standard credit, we need to be confident that the same level of emission reduction or removal would not have happened without that project there. And our judgment, which is shared, as Owen said, by others in civil society and many others as well, is that this requires the application of a corresponding adjustment when a credit is to be used for voluntary offsetting purposes. And this application ensures that the emission reduction or removal comes on top of the action that the host country takes to meet its NDC, and that it won't, in fact, displace or defer action that would otherwise have been taken. We know that this displacement won't always happen, but without a corresponding adjustment, it's a possibility, and that possibility means that the integrity of the credit cannot be assured. At the same time, we're conscious that readiness is not yet in place in many governments to make corresponding adjustments or to issue letters committing to them, and that Article 6 negotiations are still ongoing. So as we set out here in this proposal, we've proposed a staggered introduction of this requirement of corresponding adjustments for these purposes. So in developed countries, the requirement will come in for vintages from this year. In most developing countries, we've proposed that the requirement comes in from 2023. And in LDCs, landlocked developing countries, SIDS, small island developing states, and conflict zones, we've proposed that it comes in from 2025, subject to an assessment that the circumstances allow for this. And in practice, what we will require is a letter of authorization and assurance from the host government or a similar document which confirms that a corresponding adjustment will be carried out. Next, please, thank you. There are several other things that I want to share here. The first is that we, of course, have a dependency on the Article 6 negotiations on this point. And if Article 6 guidance is not adopted this November, or if it's materially different from expectations, we will, of course, review the proposals which we put forward here. And another point is that we are very open to feedback on the best way forward here. And we're actively interested in speaking to project developers and other stakeholders to make sure, following the principles which Owen shared earlier, that we're doing this in a way that is fair and thoughtful and considerate. The second detail I wanted to include there was that our proposal is that this requirement is applied for domestic use cases as well as international, so where a mitigation outcome is generated and used in the same country. And also our proposal is that this is for projects outside the NDC as well as inside. So we will look carefully at the outcome of Article 6 negotiations on that point. On to the next slide, please. So just taking a step back here, we recognise, as Owen said earlier, and we've said kind of in the past as well, that this is an issue which is of significant interest and importance to project developers, but also many other stakeholders, and that this is a new concept for many. And as I said just now, we are very willing to speak directly to project developers and other stakeholders to answer questions or to discuss particular circumstances, and we included that message in our consultation as well. And we are particularly interested in written feedback on these proposals. And at the top here are the 4 questions we included in our consultation, but we're interested in feedback and ideas beyond that as well, because this is an extremely important transition and it's important that we get it right. And the final point, which I've included here at the bottom on further information, we have in our consultation put forward the rule updates that we consider necessary to address the double claiming risk. But there are certain things which need to happen which are outside of our control. One is that, of course, there is a need for host government capacity building in order to build up the capacity to issue the LOAs and to make corresponding adjustments. And secondly, we need to see the adoption of Article 6 guidance. And these are things which we will do what we can to encourage and work with partners on, but it needs action outside of gold standard as well. And the final point on here as well is I hope that many of you will have seen that alongside the consultation, we also published a separate document on corresponding adjustments, which provides more detail on some of the ways in which this will be implemented in terms of the registry, in terms of what needs to be in a letter of authorization and assurance, and some other elements as well. And a final point which we've included in our consultation that I want to cover briefly here is around alternative claims. So as I set out in the previous 2 slides, we will introduce a requirement that where credits are used towards voluntary offsetting claims, a corresponding adjustment must be in place, and we'll introduce that over time. But we will also continue to issue credits that do not have corresponding adjustments tied to them, but credits that still follow all of the same rules, safeguards, and other requirements the gold standard has. And the reason for this is that we see the potential for demand to grow for such non-adjusted units, where voluntary buyers are happy not to make a claim to be offsetting their emissions or to be carbon neutral, but instead to claim to have financed reductions or removals. And as the claim is different in that case, the risk of double claiming is not present in the same way. And this points to what Owen said earlier about market diversification. And the role that we want to play in this is not to favour one of these over the other, but instead to make sure that both of these are possible, as we've illustrated here, through updates to our rules, so requiring adjustments for certain cases, but allowing them not to happen for other ones, but also in our registry. So our registry will be updated so that this is clear and so that buyers can understand the credits they are buying and use them appropriately towards the right claim. I'm sure there'll be questions about the section I've just covered, but I just want to conclude it with a few short points. The first is that this isn't a change that Gold Standard is introducing kind of our own kind of accord without reason. This is a necessity which we see as a result of the new context under the Paris Agreement. And it's a reality that we consider to affect the market across the board. And through our proposals, we are trying to respond to it in a way that we consider to be responsible, to protect integrity, and to provide clarity and confidence for buyers and others in the market. And the role that we see here, as I've kind of tried to address through there, is firstly, for us, we want to make sure that the credits we issue continue to have integrity. Secondly, that buyers can trust the credits that they purchase and that they stand up to scrutiny. Third, that we're serving the different forms of demand that we expect to see in the future. So issuing credits that can be used for voluntary offsetting purposes, but also those that can be used towards alternative claims. And the fourth point, which I just want to emphasize again, is we see an important role for ourselves in working with our community of project developers and stakeholders through this transition and making sure it happens in as thoughtful a way as possible. And just on to the next slide. This takes us now on to the third bucket of issues, which I mentioned at the start of my remarks, which is areas of project design that we are not proposing to make rule changes for now, but where we see a potential that we may need to look again at our rules once Article 6 guidance has been adopted. And the first area here is baselines. And the purpose here is to ensure that emission reductions and removals attributed to projects are real and that baselines align with rules and developments under the Paris Agreement. And this, as Owen's mentioned earlier, is about making sure that gold standard continues to kind of represent best practice, but also to kind of work with the Paris Agreement rather than against it and against host countries' efforts. And the first requirement that we expect to need to make is that crediting baselines should be updated, taking into account host country policies. The second is that crediting baselines must be set below a business as usual scenario. And the third, that crediting baselines should be updated at least every 5 years, unless otherwise deferred by gold standard for specific project types. And that third one is already required for gold standard projects, but would be extended to our CDM portfolio as well. And there's several questions that we've asked stakeholders here. The first is around the criteria that we should, whether there are other criteria we should consider to ensure baselines have integrity and are aligned with the Paris Agreement. And then there's some questions which we're particularly interested in feedback from some of our developers and other stakeholders on, which is around suppressed demand. And there's a section in the consultation on that we would welcome feedback on and how that fits within the Paris context. And just going on to my final slide here, the two other areas we have included in our consultation. The first is sustainable development. So as we see it, looking carefully at the Paris Agreement, we don't expect to need to update existing gold standard rules and requirements in order to align with the Paris Agreement on sustainable development. But that is not to say at all that sustainable development isn't a continued priority for gold standard. It absolutely is, and there's work that we are doing to improve impact on that. So there's piloting work which is going on at the moment on new sustainable development goal tools, which some of you may be involved in. And the final element in our consultation is overall mitigation and global emissions, which is a concept which is under negotiation within Article 6 and has several different definitions which have not yet been brought together. It's not yet clear what provisions will be agreed at the UN level on overall mitigation and global emissions, or OMGE. So we have not at this point proposed any specific changes to gold standard rules. But we wanted to include this here as that it's something that we will be looking at and keeping under review. And once there is a decision at the UN level on Article 6 rules, we'll pay attention to that and see whether any changes are required to gold standards rules. And one of the options which is there in the negotiations is the option of a cancellation of a percentage of units for the benefit of the atmosphere. So we just wanted to make stakeholders, project developers aware of that development within Article 6. We're going to turn to questions in a second, which I'll hand back to Sarah to lead. But these are just a few final points for everyone to be aware of. The consultation was launched a couple of weeks ago and ends on 15th April, and we would welcome all written feedback by then. And as I mentioned earlier, are very happy to speak directly to stakeholders, including project developers as well. We've updated the version of the consultation on our website, so this now has all of the questions together at the end of the document, and we've also included an online tool by which you can submit feedback, which may be easier for some of you to do. As I kind of said through this, there are some proposals which we put forward which will lead to rule changes fairly shortly. There are others which will come in over time and others which were anticipated we may need in the near future. But for those around the transition, we're expecting to be able to implement those around the end of this year once we've reviewed the consultation feedback, design criteria, and gone through internal processes. Separate to the consultation, I just wanted to finally highlight several other things which are ongoing or which you can expect in the next few weeks or months. So We launched a consultation shortly before, or a piloting exercise, sorry, shortly before this consultation on new sustainable development goal tools, which is ongoing at the moment and will continue until the 5th of April. And these tools are there to help project developers to more efficiently monitor, quantify, and verify a project's contribution to the SDGs. The second thing to flag here is that we have upcoming consultations coming forward on 3 methodologies. 2 of these, the first 2 here, are updates to existing methodologies and are there to streamline our existing methodologies. And the third one is on modern cooking devices, which is a new methodology, and public consultations will come forward soon on these. And the final thing, which you can expect in the next week or so, are new templates and checklists to streamline processes for CDM projects transitioning to gold standard. And these templates are there to reduce the transaction time and to make more efficient the process of this transition. So we hope that those will be useful for those to whom they are relevant. And with that, I'll hand back to Sarah.
Super. Thanks so much, Hugh. And just want to echo your last point on the new introductions for streamlining, both in the methodologies themselves and also in some of the supporting tools. As we see changes coming, I know that there's a perception and perhaps a reality in some cases of more complexity, but we're really doing all we can as well to make things easier where possible. So we're working to reduce complexity and hoping that you'll find that to be true as you see these new consultations and new tools. So with that, I'll start fielding the questions that have been coming through. So thanks very much for already populating those. And the first one, I'll just say thank you to Jurt Kreilard. The point, it was not a question, but a point made that very happy with your point on responsibility. So that links back to Owen's principles that have been guiding this consultation process and the considerations for how we adapt our rules moving forward. It really does capture what we're aiming for, not trying to be difficult for its own sake, but really to protect not just the environment and the atmosphere, but to avoid either project developers or buyers who are voluntarily taking action from being on the sharp end of, say, an investigative journalist or civil society that's displeased with how things are evolving. So thank you for acknowledging that. It is helpful. There's a technical question about corresponding adjustments. The question is, what other documentation or evidence could be presented instead of an LOAA? So Owen or maybe Abhishek. We have Abhishek Goyal also on the line to answer the questions that the rest of us cannot. But I'll leave it either over. Abhishek, can you comment on that?
Or maybe both, yeah, maybe just from my side. I think the LOAA represents a really good default position and there'll be templates and processes associated. And I think what we hope to see is that host countries will take that on as standard practice. I guess I could also in future envisage a world where a country has a published policy on what they'll do and won't do, and that's clear enough that you always could refer to that. And if they're tracking and reporting accurately, then we can kind of refer to what they're doing as opposed to necessarily going through 100 individual project requests. And I could totally imagine a country wanting to do that to streamline that process for themselves, because we often hear that everybody applying for individual letters is a real resource drain. So I can imagine alternatives in the future, and we keep an open mind and we'll assess each on their own merits, but we wanted to make sure the LOAA option was in place so that everybody can at least have something to use. But Abhishek or Hugh, I don't know if you wanted to add to that. I don't have any specific alternatives in mind, but robust alternatives we keep an open mind to, I think is the way I would phrase it.
Okay, then maybe keeping on the LOAA topic, there's a comment from Mayu Sasaku, who has linking back to your point on fairness, Owen, and making sure that we, safeguard the most vulnerable projects. The comment is the LOAA requirement would be very difficult that they can already foresee. It can induce briberies and corruption, and the most vulnerable projects might not get the letters to be able to issue the credits to get the funding they really need. So the question is, are you still doing a consultation on all these proposals that you have? So maybe this is maybe a reflection on that point and recognition of the importance of it, and maybe the fact that we're remaining open on alternative routes to market.
Yeah, I think there's a lot to unpack in that question around fairness for sure. And I think, you know, we have to also be careful of not slipping into condescension of things like least developed countries. For example, we know for a fact that actually that group is quite strongly often in favor of corresponding adjustments, and one country's, you know, charging a fee for a corresponding adjustment is another country's bribery, and we need to be careful of getting in the middle of all of that. But I certainly recognize it's very much on our mind, is it safe to even ask for one in some places in the world. So I think we are open to feedback. You can read into the point about a review in 2025 for LDCs and SIDS and conflict zones. What isn't in that is what's the criteria for that review. And so we are open to hearing voices of particularly vulnerable communities where it may not be safe to ask for one, for example. What criteria could we build for that assessment? But like I say, we do have to be a little bit careful that we don't slip into condescension and say, well, the most kind of developed, the most developing countries, you know, this isn't going to work for them, when actually that's not the message we're getting from LDCs at all. Actually, I think in fact it's often the opposite. So a little care to be taken there, but we're totally open to hearing consultation feedback on criteria.
And then this next point is fairly relevant, related to that, which is the question: why is there a differentiation between developed and developing countries when applying this proposal? Like, why are we staggering rather in the way we are? So maybe just kind of reiterating that rationale.
Yeah, and Hugh, I don't want to hog the mic here, but maybe just because I am hogging the mic, the role, I think there's a commuting of our existing rules for double claiming for developed countries. It's not a perfect mapping from Kyoto Annex B rules to developed countries, but it's not a million miles away. For everybody else, the 2023 is the best known projection of when the kind of infrastructure and the negotiations will conclude. So you could read into those two things. Our view is developed countries have the capacity to do this anyway. Everybody else will have the capacity, at least on paper, to do it from 2023. And LDCs, we want to give that little bit more time too. But having said that, you'll see another clause in there that is along the lines of the host country may require it itself, and we will honor that whether it's an LDC or not. You know, if a host country writes into law, for example, that it's going to do that, then that's already a gold standard requirement. But I would keep in mind as well, one question we get from the negotiators community is to be careful to cut across the negotiations, which isn't making that differentiation, but we're making it on a rollout basis, not as a permanent fixture. So I think it would indeed be wrong to permanently not require CAs in LDCs. But I think it's justifiable to give more time to different groups. We'll obviously be keeping a close eye on the negotiations to see if those dates remain reasonable. But yeah, it's really about the fairness of rollout.
Okay, now two questions that are both around in versus out of NDCs, and I think there might be some misunderstanding about what our proposal is here. So one of the questions is to determine whether the corresponding adjustment is made identifiable. Will it require NDCs to be sufficiently detailed to know if the VER action was in their NDCs? And the other question similarly asks if the proposal is only for outside NDCs. So maybe a clarification there, and it'd be helpful to also understand why we don't see that being a differentiator. Hugh, you want to take this one?
Yeah, I'm happy to, and then others may want to add as well. But I mean, I'm looking here at I think at Philip's question, and one of the one of the issues which is raised quite regularly around the inside-outside distinction is that in many cases it's very hard to make that distinction, work out whether something is inside or outside of the NDC. And the proposal that we put forward is to require adjustments for inside and outside of NDC, so across both of them. And that in a way addresses that issue which is there. What we have said though is that we will look at what comes out of Article 6 negotiations on this point as well, because this is a big issue in Article 6 negotiations, and it may be there are solutions that come out there which we may want to look at around outside NDC. But as we've put in this proposal, our intention is to introduce this for both inside and outside. And when looking at developed countries, so those where we are requiring this from the start, the expectation under the Paris Agreement is that NDCs are economy-wide. So the issue is kind of different there. I think in many developing countries, it's a smaller scope of NDC, so the inside-outside distinction is more of a relevant one. But for developed countries, in general, NDCs we see are economy-wide.
I think as well, just a couple of other observations. One is that the nature of NDCs is itself changeable. So what isn't in now might be in the future, and we don't have control over that. So that causes us a potential headache that you think you've made a decision on a good sound basis, but then that changes down the line. And I recall, and I'll try and put my finger on it, and we'll tweet it or something. There was a study done a couple of years ago about the overlap between non-NDC activities and the voluntary carbon market, and it equates to something like 10 or 12% of the current voluntary carbon market. So we're not necessarily looking at a particularly pivotal thing that, you know, there's a great scope for us to issue into that space. That's not to dismiss it as important, but it's not what should be guiding our policy, I suppose. That might not be the exact figure for gold standard, of course, and that's a relevant point. But overall, I think we're guided by what Paris aspires to be and what is the most robust. Yeah.
Great, thank you. There are two questions that I can actually take, so I'll spare you guys. If I understood correctly, then there will be a change in the registry to show the credits pre-2020 and post-2020 vintages, and that's not exactly the case. The registry will differentiate credits that do have adjustments and do not have adjustments. Because of the staggered rollout for one, and some projects just might not pursue adjustments in the future. So that's the distinction that will be made in the registry. The next question is, in the case of carbon financing claims, it was said that they can still be retired. In that scenario, can these retired credits, can they be used to adjust companies' GHG inventory? And I would say no, but carbon offsets today cannot be used to adjust companies' GHG inventories. That's never been a thing. The GHG protocol doesn't recognize that. For some reason it does in scope 2 and REX, but does not for offsets. So there's no real change in that regard. There is a comment from Tom Morton saying that Climate Care, of course, will provide a written response. For that, we thank you. On ongoing financial need, it looks like the requirement for OFN is essentially a 5-year review of additionality. Is that correct? Or is something to be further elaborated there?
I think the answer is fairly simple here, and it's a yes, but Abhishek might want to add more to that.
Yeah, thanks. Yes, you're right. You know, it's really assessment of, you know, whether the project needs like further carbon finance or not. So in that sense, it is reassessment, you know, of the additionality, but the criteria, you know, that would be used would be different for the OFN assessment compared to what we use for additionality assessments.
And I would say that from a communicator's perspective, and one that engages often with media, that's a huge boost for the market, because that's something that often comes up as a criticism, and it's, you know, just unrealistic for the market to be able to react quickly enough, as we've seen with renewable energy. So I think it's a huge step forward for the carbon market.
I totally agree. It's a real response to criticism and trying to paint the way forward, really, that we have this. And the reason we've kind of called it slightly differently is technical. Additionality was always meant to be pre-start additionality snapshot. Did your project, consider carbon credits in advance and then need the money to get started? So OFN, while the test may be similar, we've named it that to distinguish between the two things. You might well be additional at the start and perfectly valid to have 5 or 10 years of credits, but that might change in the future. And exactly what Sarah said, there is a lot of criticism around about renewable energy, particularly long becoming financially sustainable, and we want to make sure that projects that still need that finance are not competing with ones that don't at this point. And I think that's, if you're sat here thinking, wow, is this a risk to me? If you feel your project still needs the credits, then and that should be justifiable, then there's no reason to be concerned with that. That's the whole point of this exercise.
Right, and I'm happy that it's a different nomenclature and different criteria, because I know that it's often that I see additionality and ongoing financial need conceptually conflated in commentary around the market. I heard on a Clubhouse just last night someone confusing the two, and so I think it's important that we just create that distinction. Harry Clemens shares a question, first stating that alternative claims may be very important to raise ambition, as we know that the sum of NDCs is not sufficient to keep global warming under 2 degrees. Will Gold Standard help create demand for these alternative claims? The answer is definitively yes. I've actually just published an opinion piece in Carbon Pulse just today that you may soon see, and I realize that that's a bit preaching to the converted or to a specific stakeholder audience. But that's something we're very committed to, not just through our own channels, but working with partners to align and build the case for these types of claims. I think we've seen already that WWS Corporate Blueprint for Climate Action and Nature, got that not quite right, but you get the idea, is already paving the way for this, and we'll look to partner with them to the extent possible to also to build that case in addition to others. So absolutely is the answer. Thanks, Harry. There is a question from Esther Mertens, specific to an example of agriculture and soil carbon. How are the emission reductions demonstrated in soil organic carbon GS value chain intervention guidelines that can be used for SBTs different from the purpose of a GS financial claim based on the SOC framework? So Owen, I'm going to give that one to you.
Yeah, sure. I confess I'm not a soil carbon expert, but I am a scope 3 expert, so I can at least help with that part of the equation. There's a number of differences and similarities. Actually, what it points to, I think, and Sarah just mentioned WWF's work, is that the way that these things interact, or the need for these things and instruments to interact, is getting ever closer together. So what I often say internally is that everything is everything at this point. A soil carbon project could be a scope 3 project. It could also be a carbon market offsetting project, or a claim to have finance project, or it could end up in Article 6 between countries. But it's the same underlying action. So go right back to the top of the call when I said there's a reason to align with Paris. Think of that soil carbon project and where it might be able to be reported. And we also have to unpick where, if you report it in one place, you can't report it in another because of double claiming. So we're kind of trying to deal with a 3D chessboard in many ways, in the sense that the interaction between corporate inventories, national inventories, and market-based instruments, we're kind of we're in a useful position because we can see all sides of that. But to get to the point on the specific difference, to do it in your scope 3 versus a claim to have financed, the big obvious difference is one needs to be in your scope 3 boundary to be claimable under science-based targets, and the other is more about whether you go beyond your science-based target. So there's no, Microsoft, for example, don't have agriculture in their scope 3. They're not an agriculture company, but they could finance soil organic carbon benefits as one of the things they could do to take responsibility for their residual emissions. Take a Cargill or a General Mills or a Mars or a Danone, companies with agricultural footprints. they might do the same project, but they actually need it for their scope 3. It is genuinely in their scope 3. So I think the main difference is where it's being accounted for and why. And the second would be, those are two different applications. The level of expected MRV for scope 3 isn't the same as we would expect for carbon markets for voluntary offsetting. So we rightly expect very high quality MRV to use something as an offset. That's not to say the MRV isn't quality in scope 3, but definitionally it's not the same as in voluntary carbon markets. So yeah, I would say it's a scope and boundary thing, and it's an application thing, and we're working hard to map out all of those different interactions. Yeah.
Thanks, Owen. Another one that I can field comes from Wayne Sharp, asking how we would determine or monitor alternative claims, i.e. finance over offset. We will not be able to ensure 100% compliance. Gold Standard does not have that ability to monitor every claim being made. What we can do is set guidance and expectations, and we can reserve the right to take action in the event that we discover claims not being made appropriately. So we will reserve that right. I think also we will count on all of our partners, many of you who are on the line here, to guide your corporate partners and buyers appropriately. So I think it'll be a team effort. Ultimately, there might be some, if there is misuse of claims, that often, leads to the media getting involved or the public, and so we wish to avoid that to the extent possible. So we really hope that we can count on all of you to guide your companies and your partners through this process. Going back to financial need, how will we work with verifiers to ensure that the tests to show ongoing financial need are robustly and objectively undertaken? And there was a follow-up, this is from Guy Turner, whether we'll do spot checks.
Yeah, maybe I can kick that one off, but I'll go in reverse order. For sure, there'll be spot checks. So we operate a slightly different assurance system to other standards, as I understand it. I can't speak for them clearly. Because we have a broader scope in terms of the safeguards and SDG contributions, we've always had systems of review of the work of VVBs. That's now largely with SustainCert, our sister company, but Gold Standard itself also conducts QA, QC, and when we launch a new technical tool like OFN, clearly that's something we would spend extra time and extra sampling to keep on top of. In terms of how we make it objective, well, this is still somewhat under discussion. I think we can expect, and this is my kind of crystal balling here, I suppose, to some extent, additionality to move in the direction of kind of performance benchmarks for sectors. So a series of tests that a specific project type might have to kind of pass to be able to be eligible and additional. And in a way, that same kind of logic can extend to OFN. I think the key to making that work, as whoever asked the question, I'm sorry, I can't see the questions, but the key to making that work is to make them as black and white and as non-arbitrary as possible. And I think that's one of the big criticisms of previous iterations of additionality, is that you end up in some quite grey conversations. And I think the future of additionality, as it kind of ratchets with the ambition of Paris, will need to be much less binary, much less arbitrary and much more binary in that sense. But I'd equally say that's our aspiration. We haven't developed that out yet. But we'll take as feedback number one that that's what it needs to be to make it easy to use and clear and straightforward to understand. But yeah, Hugh, Abhishek, feel free to add to that. I know we've got work to do yet on OFN, but that's my take.
Can I keep you on the topic, Owen, to respond to a question from Sarah Carciente? On additionality, some NGOs are asking for improvements on additionality and noting that Gold Standard doesn't have a proposal there. So if you can maybe clarify our intentions around additionality.
Yeah, so I think actually I should have said this at the start of the call, and I'm sorry I didn't. This consultation is as Hugh pointed out towards the end of the call, should be read in the context of a series of things that will need to change, and some of those we can change now, and some of them will have to come forward in the future. And additionality is one of those that will come forward, but we are already working on it in the context of Article 6 and voluntary carbon markets, and we've made recent announcements and there will be more to follow on that. Again, a kind of crystal ball on this, as I said, is that I think the general barrier assessment approach for additionality will continue to make sense in the Paris era, provided, and this is where kind of topics start to overlap with each other, provided the baseline definition is as Hugh described. So then barriers make sense, and that those barriers are assessed with performance benchmarks rather than general, first of kind or penetration rate type barriers that the current CDM additionality tool allows for. So I think you'll see an evolution. We're pretty convinced and confident that additionality remains completely indispensable to markets. But I think evolving the baseline and switching to a sector-based performance benchmark approach is where this will go, and you can expect to see more from us in the coming months. But yeah, Hugh or Abhishek, again, feel free to pile on that. We're not saying that much about it at the moment, so I don't have a lot to add from my side.
Okay, then a couple of questions about LOAAs. One is from Tiffany Potter that asks, why retroactively date the LOAA requirement to January 2021 for developed countries if Gold Standard does not even have an LOAA draft created yet? And then a follow-up or a different question from Maria Carvalho. Are there any countries engaging with the GS template of LOAA, or at least discussing this? So I guess there's some confusion about whether the template exists. So we could tackle that first.
Again, yeah, sure. Maybe I can talk about the philosophy, and then Hugh, Abhishek on the template, although that's in hand. So I would see the developed country piece not as a retroactive rule, but I'm not sure what the word is, a commuting of our previous rule for Annex B countries in Kyoto. And I appreciate that's not a perfect mapping, but we don't have projects in places like Saudi Arabia, for example, that would be the ones that weren't in Annex B. So the alternative, I suppose, is we could leave our rule that says Annex B countries, which is still technically in place, require cancellation of AAUs, but they can't get those AAUs anymore because we've moved away from the Kyoto era. So it's a Hobson's choice. We can either leave a rule in place that nobody can meet, or we can put a rule in place that requires a template to be developed. So we don't view it as a retroactive rule application, more of a rule clarification on what our Annex B requirement now means, if that makes some sense. But for sure, that does entail putting the templates and the process out there for people to use. I would also just say before I pass to Abhishek or Hugh on the template update, I was a little flippant there. We do have a small handful of projects in developed countries, and I think we've now spoken to all, if not the majority, and shortly will have spoken to all of those. We completely recognise the hole that puts those projects in. Many of them are already dealing with the cancellation of AAUs, and we'll work with each of those small handful of projects on a case-by-case basis to figure out how to help them through a difficult period in the spirit of the fairness principle from earlier. But Hugh or Abhishek, I think it would be good to quickly describe the steps for the process and the template to come out.
I can say something quickly on this, and just also addressing the question from Maria as well. I mean, so it's still, of course, very early and early on this point, but I mean, there are some countries who we are starting to speak to about what this would look like in practice. So those conversations are starting to happen there. So that's one thing to say. A second thing, I mentioned this in the alongside the consultation, we published a separate document which sets out more information on the LOA process. So hopefully some of you will have seen that, but if not, it may be helpful to kind of look through that. And the third thing to say here as well is that a lot of work on this has already been done in the context of CORSIA, and we try to point to that in our consultation. And it's something which we haven't talked about here. We're talking in the context of the voluntary market, but a lot of the applicability is sort of there for CORSIA as well. And there's work which has been done to develop an LOA to look at the process and how that would work in practice. And it's something that we are, of course, thinking about. So when we're talking about a distinction in our registry, that's relevant for the voluntary market, but it's also relevant for CORSIA as well.
Great, thank you.
So just one more point to clarify with respect to the LOA. So it should be noted that this LOA is not required like when you apply to gold standard. It is not even like essential that you submit to us at registration or at issuance. The latest point in the process when we need this letter is when you are retiring the credit against any offsetting claim. So assuming like 2021 vintages are like kind of monitored and issued, and when they come for retirement purposes, it would definitely be like earliest would be Q4 this year, right? Like before any, like realistically any 2021 vintage credits from a developed country can come up for retirement, would not be before Q4 like this year. So I think it's not really retroactive application from that perspective.
Thank you, all of you. We're at time, but I'll try to squeeze in a couple more. There's a series of questions around corresponding adjustments. If you want a CA on the side of host country, which country would benefit on the other side of the CA, and how is this matched with fairness when the corporate using the VER is not under a legal emissions cap? In that case, the receiving country gets an emission reduction for free, more or less. I'll take a stab at this and tell me if I'm wrong, guys. But I think it's fairly unlikely that this will show up in the inventory of any country where a company is making an offset claim. I don't think that's ever been known to happen. I don't think we anticipate that it will happen because the level of granularity doesn't get to an individual company's reporting. But opening that up to criticism if my colleagues are.
No, I think that's right and fair. We don't envisage voluntary offsetting. The double claim isn't between the host country and the company's own host country, if that makes any sense. The issue of double claiming is more, as it says on the tin, I suppose, is about the claim being made by the company itself. Happy, like if people, I've looked at this from a number of angles and I can't see many, if any, situations where we cause a Paris double count in voluntary offsetting. But if people can see them and explain them, then like we would obviously want to address that. There are instances of some countries, I think Swiss legislation talks of this, that companies should buy ITMOs, so Article 6 units for compliance purposes, but then of course Switzerland and the host country then would make an adjustment, and Switzerland would choose whether to include it in their inventory, and that's a Swiss legislation thing, I suppose. But I can't see a way that it could inadvertently happen through a voluntary offset. Like I say, we're addressing a different issue to Paris double counting. Yeah.
Just one final, I know we're out of time, but one final thing that on this, the term corresponding adjustment, the corresponding part, I think is unhelpful when you're looking at the voluntary offsetting market, how this works, because the corresponding implies there is another country on the other side. But in these cases, it's an adjustment by the host country, but there isn't an adjustment by a receiving country. It's just an adjustment to reflect the fact that this is not going to be used by the host country and is instead claimed by the voluntary offset, the voluntary buyer. And it's similar to CORSIA, where for CORSIA, if a host country is to make an adjustment, the offset doesn't show up in the country where the airline is based. It's something which goes towards the international thing. So the word corresponding, I think, is unhelpful when we're thinking about this, but the mechanism still applies absolutely, as Owen's just described.
It's a very good point, Hugh. Thanks for that. We are over time, so we did have a few questions that we could not get to, and for that we apologize, but we very much encourage you to submit your questions to standards@goldstandard.org, as well as official feedback we're happy to take all of your questions and ideas and more official responses to the consultation questions that we've shared with you. So again, this has been an ongoing dialogue and will continue to be one. So thanks very much for your thoughtful input and questions, and we welcome ongoing conversations moving forward. Thank you very much.
Thanks, everyone.
Thank you. Bye.